Hello everyone, another week of Law, Crime and Punishment is upon us, and it is week 12, part 3 of the Commonplace of Law series. The reading for this week was not taken from the book we were reading for the past 2 weeks, The Commonplace of Law. Rather, it is an article written in 2003 by the same two authors who wrote the book, Patricia Ueck and Susan Silby. In these past couple of weeks, we've been discussing legality and legal consciousness. Legality, I remind you, refers to the legal structure within which we operate, and legal consciousness refers to agency, our various ways of operating somewhat independently within that structure. Now I want to take a step back and discuss the broader context of this conversation, the purpose of this book that we've been reading over the past couple of weeks. Every good academic project, whether it is a book or a paper or a presentation, is essentially an attempt to answer a question or to solve some kind of a conundrum. Something about social life that begs attention, that doesn't make sense, that bothers the researcher, who is then trying to discover the answer to that conundrum, or the solution to that conundrum. The conundrum that Ueck and Silby are addressing in The Commonplace of Law is what they term legal hegemony. That is, the legitimacy, durability, and power of the law. And essentially they ask, what makes the law as a social institution that is, so powerful? Now here's the more elaborate, more detailed version of that question. Ueck and Silby are essentially asking, even though the law is far from perfect, even though in many cases it is counterintuitive and it doesn't make any sense, such as the case with minimum drinking age laws, for instance, even though the legal system keeps failing us over and over and over again, take the O.J. Simpson case as a prime example here. Even though it is due to the law and the legal system that we ended up with 2.5 million Americans behind bars. In spite of all of the above, we still, as individuals, both as individuals and as a collective, believe in the law. It is a sacred institution and we are all believers, often without even being aware of it. Now, if that is indeed the case, state Ueck and Silby, how is this possible? The term Ueck and Silby use for the phenomenon they're trying to explain is legal hegemony. Hegemony meaning a dominance that does not require force and is often unseen and unrecognized. We believe and follow the law without being coerced to. We do it ostensibly of our own volition. So again, using the correct term now, the question that Ueck and Silby are addressing in this book is, what makes legal hegemony possible? And the answer, as you could have probably guessed, relates to the three types of legal consciousness we've been discussing these past couple of weeks. Now remember, these three types of legal consciousness are the result of the research done by Ueck and Silby and a team of research assistants back in the 90s over a number of years and following hundreds and hundreds of interviews. Following all those interviews, more than 400, they eventually came up with three ideal types, three ways that characterize how people, that is they, you, I, everyone, think about, feel about, and do law. After going over the transcripts and all the data that they managed to obtain, the ultimate conclusion the researchers ended up with is that these three ideal types of legal consciousness, three ideal types of how people think about the law, work together to sustain the power of the law. Work together to make the law powerful. Now notice that legal consciousness, according to the formulation you see on the screen right now, is a social practice embedded in an ostensible paradox. On the one hand, law is perceived as a supreme, sacred ideal, that is, before the law. On the other hand, law is utilized as a game within which rules can be deployed, manipulated, invented, or even ignored, depending on specific personal needs, preferences, and desires that would be against the law. The three types seem to be almost contradictory then. How could they work together to sustain and reproduce the power of the law? This paradox, however, does not undermine the power of the law, according to Urick and Silby, but rather the opposite. These contrary views regarding the law serve simultaneously as both ideal and practice, and that is what allows legality to operate as a hegemonic, that is, an unrecognized, uncontested power that sustains everyday life. And in the word of Susan Silby from 2005, because legality and legal consciousness have this internal complexity among and within the common narratives, the rule of law achieves hegemony. Any particular experience can fit within the diversity of the whole. So essentially, one way of understanding this argument is to see the three types of legal consciousness as some kind of a broad fishnet that is able to absorb any type of legal experience and fit it with the overarching project of sustaining law's power and legitimacy. Now, I want to conclude by saying that I do understand that this might seem somewhat confusing and that it is a complex, somewhat vague argument that requires a lot of imagination and creative brain power. That being the case, I encourage you to watch this video again, maybe even go back and read chapter 3 of the book, The Social Construction of Legality, again. Remember, you will have to understand this theory in order to do well in your final podcast assignment, so please go over the materials and, as always, let me know if you have any questions or concerns. Hope you have a wonderful week. Bye-bye.